On this morning's docket. That is case number 104940, City of Wichita v. William J. Molitor.
Good morning. May it please the court, Michael Whalen on behalf of the appellant William J. Molitor. And Chief Justice, with your permission, I'd ask for a 5-minute rebuttal time.
5 minutes is granted.
Based on the standards set up by the Kansas Court of Appeals regarding the evidence of horizontal gaze nystagmus, we might as well go ahead and do away with probable cause hearings because it's a lesser standard of proof, and we might as well just go ahead and use polygraph. And then if they pass, it's dismissed. If they don't, it goes ahead. Because it doesn't matter, apparently, that this is inadmissible evidence just because we're dealing with a lower standard of proof. That's what the opinion says. But under KSA 60-402, the rules of evidence are applicable in all cases unless they are altered by statute. An example of that is probation violation hearings where by statute the legislature has said we will allow hearsay statements, letters, and documents to be admitted because you don't have the full panoply of rights that you do in a criminal case. And so absent a move by the legislature to make horizontal gaze nystagmus evidence admissible, it's not admissible. Well, this court has said this for many years.
Why does the legislature have anything to do with it?
Because by statute, specifically 402, states that unless the statute lowers a standard of proof, that it's not to be altered. And HDN...
We've said before that we're going to let the scientists resolve scientific disputes. You're saying we can let the legislature decide what's reliable evidence?
I think that's well, if HGN...
Can the legislature say Ouija boards are permissible to use and the officer gets a yes on the Ouija board, then we have probable cause or we have reasonable suspicion? The legislature can say that?
I think that's what the Court of Appeals has already said, ostensibly, because an officer has been trained in HGN. They've said he can rely on that in assessing his reasonable suspicion.
So if the law enforcement training center trains on Ouija boards, then that'd be okay?
According to the Court of Appeals analysis, yes, Your Honor.
What about 2232-16, which seems to indicate on the suppression hearing that the court can take evidence on any fact that may be relevant?
Well, relevance is really important, but it also has to be admissible first. And HGN evidence is inadmissible. And you're absolutely right, Your Honor. This court has said repeatedly, we will leave it to the scientists to determine whether or not HGN falls under the Frye test. But we have to also keep in mind...
Well, is the Frye test a rule for 6402 purposes?
Well, it's 6456, the admission of expert testimony, which has basically, to which Frye applies. Because that's the only way the scientific evidence really is admissible in that way. Until such time that this court has said...
6456 really deals with the expert, whether the expert is permitted to testify. The Frye test goes to the basis for the opinion.
Correct.
Because we've said, Kuhn said pure opinion is not subject to the Frye test kind of thing, but I see a difference between the Frye test and 456. The Frye test has to do with the underlying scientific reliability.
Correct, but the way the scientific reliability evidence gets before a trier of fact is through an expert. Until such time, and I believe this is what the court said in Shadden and Witta, is that if the Frye test is proven at some point, then we'll grant admissibility. And kind of like we've done with the field sobriety tests, that There is a scientific basis. They've been accepted by the court. They have passed Fry. Therefore, we no longer have to have expert testimony or foundational basis for that information to be admitted. But no such finding has ever been made as it relates to HGN. And that's the distinction, Your Honor. Until we get that expert who can testify and a court says, and eventually this court says, HGN meets the Fry test and is admissible, it is inadmissible. And what we've done, and through the Court of Appeals and the District Court, is said, well, because it's a lower standard, this inadmissible evidence is admissible through a non-expert because he was trained to do this test.
But there are 5 states that do not allow the horizontal gaze nystagmus at trial, but allow it to be used for a probable cause reasonable suspicion.
That's correct, Your Honor. There are also 41 states that have adopted the federal rules of evidence. Kansas has not. Just because the other states are doing it doesn't mean that they're right or that it's applicable to the state of Kansas and our legal setup. The other courts make their own decisions. In this state, we have held that HGN is inadmissible because it has not been scientifically validated legally. Therefore, it is excluded evidence and not admissible in any situation, barring either it being found to have passed the Fry test or legislative fiat. Because that's really what it would take, because it's because this is this lower standard that we're creating reasonable suspicion, and it's within the totality of the circumstances of the realm of the officer's knowledge at the time, is the reasoning behind the Court of Appeals to say, this is okay because he's been trained. He uses it as an indicator. Well, I think the same analogy is applicable that Justice Johnson raised. If an officer is trained in the Ouija board and it comes up and says yes, well, it's the exact same thing as using horizontal gaze nystagmus to request a preliminary breath test. Because it's a lower standard, this officer believes in it, relies on it. All left-handed people get drunk more than right-handed people. This person's left-handed. That gives me reasonable suspicion.
Is there a distinction between admitting the evidence to prove what occurred and what went into the officer's thought process in establishing reasonable suspicion, as opposed to the reasons we have the Fry test to prove the fact to the jury? And we don't want the basis of the Fry test being that we don't want the jury to put too much emphasis on an unscientifically proven theory. But here we're looking at what did the officer do and what went into the components of that officer concluding there was a reasonable suspicion. Is there a distinction there that makes a difference in this analysis?
None whatsoever, because even though that is one of the reasonings behind not admitting it, the influence of scientific evidence on a jury, the fact of the matter is it's inadmissible. Regardless, it doesn't make a difference.
It's inadmissible to prove the fact, but is it inadmissible to prove what happened?
Yes, because it's still not scientifically valid.
Isn't that
Same with the polygraph. I see no distinction between the two.
isn't that part of reasonableness? I mean, the ultimate arbiter of whether reasonable suspicion existed to seek the preliminary breath test is the court. And the court can look at the entire universe of what was available to the officer. And if HGN is unreliable, as a matter of law in Kansas so far, and the officer testifies that he or she relied upon it in forming reasonable suspicion to ask for the test, that's part of the court's analysis. The officer relied on something that is, as a matter of law, unreliable at this point. I think that's what my colleague's getting at.
I still disagree. I don't see
Okay.
how it magically becomes okay for consideration.
No, it doesn't. It's in the universe, but the court's still free to say, well, that part is unreasonable.
But we obviously, in this case, the district court didn't look at it that way. In fact, it opined that HGN was admissible, and the court was relying upon that to support its decision.
I understand that this case may be particular, but I'm trying to get to the theory or the mode of analysis, and I think what she was suggesting is that it was a factor in this case, and isn't the court free to say that that's a negative in terms of the existence of reasonable suspicion?
I don't believe so, because there's no way that it works as a negative. I mean, at best, it's a nullity.
But doesn't the court have to know what the officer based the reasonable suspicion standard on? What if HGN was the only thing that had led this officer to the conclusion that there was a reasonable suspicion driving under the influence?
Absent foundation for its admissibility, its reliability, its acceptance, no, the officer can't just testify about, hey, I waved my finger 3 times, he had 6 violations. I was trained to do this, count this, and that's my reasonable suspicion. We still have no basis before the district court in this case, or any court, that says horizontal gaze nystagmus is a valid means of testing intoxication level.
I'm sorry.
Our test for reasonable suspicion is that it must be based on substantial competent evidence. And your argument is that competent evidence means admissible evidence?
Yes, Your Honor.
But we also say in determining reasonable suspicion or even probable cause that we look at the quantity and the quality. And so isn't this just a matter for the trier of fact to look at and determine that this is of a lower quality because it's less reliable? But not to exclude it entirely because it's something that the officer relied on. But then to determine what the quality of that evidence is.
I believe this court has already clearly told district courts that this evidence is unreliable and is not admissible. There's no special rule that allows in some lower level hearing that inadmissible evidence suddenly becomes admissible. Without a scientific basis, it is not for consideration by the district court. It's not a totality of the circumstances because it doesn't get there without foundational evidence that this is acceptable practice. And I would say to go the other way, Your Honor, if we're going to say, okay, judges, you can go ahead and consider this, then this court needs to also enter a dictate saying this is unreliable evidence and has not met a scientific standard for admissibility yet. So think of it that way, because we're not talking about judges making an independent evaluation of the validity of HGN. They are only to consider the evidence put in front of them. And if nobody is there to explain the validity, invalidity of horizontal gaze, then the evidence isn't before the court to allow it to consider the foundation as to whether it's relevant, competent, admissible. So to independently say we can't, in the course of this hearing, the judge can make his rulings only on the evidence presented. And if the evidence presented doesn't give a valid basis for acceptability of HGN, then it hasn't been accepted by this court by a previous finding that it has passed Frye, then it cannot be considered by the district court.
I think we're pretty close.
Okay.
What we were trying to suggest is about where you've ended up here.
Okay. Well, that's good.
That admissibility isn't the crucible, but reasonableness or competence or quality are the crucible, and that the responsibility for determining that can still be put into the hands of the district court. It's just that they need guidance on what the law is in Kansas on HGN. Do you understand what I'm saying?
I think I do, but I have to still disagree.
Okay.
Because if it's not admissible, then it's not considered by the court and can't be.
Well, we'd have to overturn our Whit decision, because in Whit we said that before the court rules on whether HGN evidence satisfies the Frye admissibility requirements, the trial court first should have an opportunity to examine, weigh, and decide disputed facts to determine whether the test is sufficiently reliable to be admissible for any purpose in Kansas, end quote. So basically in Whit, we were saying it's inadmissible for any purpose until the trial court goes through the Frye analysis. So we'd have to overturn Whit to allow it to come in for any purpose, for reasonable suspicion.
Yes, Your Honor. And I thank you for bringing that up. That is one of the citations in my brief, or my supplemental brief to this court. That has been the holding of this court, and I guess maybe I wasn't saying it as clear, is it's never been admissible. This court has not found admissibility, and I think the benchmark is admissibility, not competence, not relevance, but whether or not, under the state of the law as it stands, can this be considered and admitted as evidence on the record?
Do we have any further questions of counsel?
I have one, Chief. Absent the horizontal gaze nystagmus test, is there still reasonable suspicion based upon the officer's observation of his driving, his subsequent observation of his conduct before him, the odor of alcohol, there were some other indicators of intoxication. Absent the horizontal gaze nystagmus, aren't we still where we're at with reasonable suspicion or probable cause to administer the test?
We are not, Your Honor, because
Why?
the Court of Appeals, the District Court, both found that as part of their analysis, one of the issues was Mr. Molitor took a step while he was awaiting instructions.
I understand on some of the field sobrieties he had more or less indicators than not, but there were still other observations.
But his indicators were actually contrary to a finding of being under the influence, because he scored only one indicator on both the walk and turn and the one-legged stand.
Oh, I understand that. So maybe they weighed in his favor, but there were other observations. The driving, the odor of alcohol, the other typical kind of indicators that leads someone to, an officer to a preliminary breath test.
Well, there were no driving indicators. There was, he bumped
I thought he hit the
with his
curb. I
tire
thought he
when-
hit the curb. Wouldn't that be an indicator?
I don't believe so, Your Honor. It's while he was being pulled over by the officer. It wasn't as a matter of his course of
No, I understand,
driving
but-
regularly.
yeah.
Yes, it can be considered. Of course, it can, Your Honor. And then there was bloodshot eyes, odor of alcohol, admitted to having consumed beers.
That's not enough?
Not when the other admissible scientific evidence indicates that he was not under the influence. And the problem there is that I don't believe the Court of Appeals analyzed or took into account the field sobriety test in the manner that they should have. This court,
You mean the test isn't substantially dissipate? That's what they said, that the passing the field sobriety test didn't substantially dissipate the reasonable suspicion from the other indicators of alcohol consumption.
but they also included that as part of their indicators for why reasonable suspicion wasn't met, that he had one leg off, that he did put his foot down at 24 seconds. And I think that kind of goes against this court's ruling in Pullman and Edgar.
The National Highway Traffic Safety Manual speaks to the number of clues for the walk and turn and the one-leg stand, and they relate it to a 0.1 alcohol concentration. Is there any relation or indicators on the horizontal gaze nystagmus? Is that in the manual? I didn't look it up, but you understand that here it was 6 out of 6 clues. Is there for the HGN? Do you have to have 3 out of 6, or do you have to have what is it to fail on that? Do you know?
I do not, Your Honor. It's been a long time since I looked at
Well,
it.
and that's fine. Thanks.
Any more questions? I see none. Thank you, counsel.
Very good. Thank you, Your Honor.
Hey, please, the court. Good morning. Sharon DeGraff on behalf of the City of Wichita. I think it's important for the courts to, or I'd like to reiterate why we're here and what the hearing was about in this particular case. And that is that this was a motion to suppress, and the allegations, and the only allegations made before the district court was that there was not a reasonable suspicion from the officer. And it was not a jury trial. This was a hearing in front of a judge, and many of the facts and rationale of Witte simply do not apply in this case. The purpose of the opinion.
What part of any purpose is unclear?
Whitty, the purpose of the Fry test, or one of the statements in the Whitty decision, was that a jury with the.
Well, I understand the opinion, but what we actually said in that is that before that, this is going to be admissible for any purpose, a trial court has to have the opportunity to examine, weigh, and decide disputed facts to determine reliability. And we said to be admissible for any purpose in Kansas. Now, to me, that's not ambiguous, equivocal, whatever. It tells the prosecution what it needs to do to use an HGN. It has to get an expert in and let scientists determine disputed scientific facts and establish in the state of Kansas that this is reliable enough to use for anything, that it's not just a Ouija board.
But I think in Whitty, the purpose of the HDN in Whitty was to show that so many clues, and in Whitty it says it four.
It was talking about the purpose of the Fry test. When it talked about that, the jury putting insufficient emphasis on scientific, but the holding's clear. I mean, what's equivocal about admissible for any purpose in Kansas? What's equivocal about that?
But I think that this court's opinion in Shadden allows the court, as part of the whole global, the whole universe of testimony, not necessarily what the results of the test were, but what the officer used, whether they're reliable or not, what the officer did in determining whether or not there was reasonable suspicion to walk through that process. And the court in Shadden said that field sobriety test results can be used as circumstantial evidence of intoxication. And in this particular case, that was the purpose of this testimony. And if you look at the testimony that the prosecutor elicited, he didn't ask a lot of those technical types of questions. He asked much more of the types of questions that this court approved in Shadden. How many indicators there were? Did they pass or fail? He didn't ask the technical, detailed Fry type questions. What does the alcohol do? And I would agree that had the prosecutor gone on and asked, alcohol does this to the eye, alcohol does that to the eye, certainly Fry would have been required.
Do you agree that it's not unlawful to drink and drive?
I would agree.
You could have one beer, or you can have a glass of wine with dinner and drive home, as long as your weight and whatever is such that you're not over 0.08. And so long as your ability to safely operate a vehicle has not been impaired, you can drink and drive.
Yes.
And why does the HGN tell us anything more, even that? I don't even know if it tells us whether someone's consumed, but why does it tell us that someone is incapable of safely operating a vehicle? Because it's not enough just to show that they've consumed alcohol.
I agree. And I agree that HDN alone is not enough to establish. And in this case, the ultimate goal was to establish the reasonable suspicion on the officer. And you can't look at, and it would be contrary to the Pullman decision and a number of decisions of this court, to look at just one test. And we go back to the prior question of, if you exclude this test, was there enough in this case? And there clearly was. But the court, at a preliminary hearing or a motion to suppress, ought to be able to consider and weigh, because that's what the trial court should do, the weight of that testimony. If it's a Ouija board, then the judge, in its discretion, is going to go, it's a Ouija board, that's irrelevant. I'm not even going to consider that. The defendant's foundational arguments in this case, But
what if the judge did consider it? What if the judge did consider the Ouija board, or probably more accurately, the lie detector? He hooked him up to a polygraph and said he was lying about what he drank. What if the judge did consider that?
But I don't think that we have that scientific testimony in this case. And I think you look at the Shadden opinion and you weigh the lay testimony versus the scientific testimony. And in this case, there could have been, and there was on the other field sobriety test, cross-examination. And
I
there
don't
wasn't.
understand. The lay testimony, was this lay testimony?
This was from the officer.
Well, but you said there's a difference between scientific and lay. I understood you were trying to set him up as a expert because he had law enforcement training on how to administer. Is he an expert or a lay?
Well, I don't think that I can ever establish that this officer meets the scientific criteria under Fry for HGN. So I think that under 6456, then any opinion regarding HGN would have to be a lay opinion.
So, and he gave the opinion that he failed the HGN.
He gave his opinion that he gave 6 indicators of the test. And the prosecutor then followed up with the question of, and those indicators would indicate that he may be under the influence of alcohol, and the officer said correct. And that's all the testimony we have on the HGN issue.
Why is that reliable? Why is his testimony that 6 clues on the HGN gives reasonable suspicion that he's driving under the influence? How do we know that?
I think that it's one piece of the reason.
No, how do we know that that's any piece? How do we know that that has anything to do with the question at hand when we don't have any evidence that that test is reliable, that shows anything? I've never seen that test even shows that someone had a beer. We never established that test. We know that coordination, and we scientifically, the walk and turn and the one-leg stand, that coordination is directly related to alcohol consumption. And the more uncoordinated you are, the more likely you've consumed more alcohol. But we don't know that about fluttering eyes, do we?
Well, and in Whitty, and you are correct. In this case, there was no evidence or no testimony that was presented that would show any correlation between alcohol and what factors the officer was looking for. That is correct. In Whitty, there was a discussion as to what alcohol effect has on HGN. Whitty, I think the downfall in Whitty, or the issue that the court had in Whitty, was that there were other factors that could cause the same type of movement in the eye. And therefore, without that extra scientific information that was not presented, they could not find that it was reliable.
Are you arguing that HGN is a scientifically valid test or instrument to establish alcohol use? I mean, haven't we, this for over 20 years, 30 years, this test has been invalidated. It's never been recognized in Kansas. Why are you still using it? I don't understand why we're here in 2014 and we have officers out there apparently being trained and using a test that's scientifically invalid. Explain that to the court. I don't understand it.
I don't believe that I'm going to argue that it is or is not invalid, but I do.
Why are they still using it?
Because I think that the National Traffic Safety Institute, and certainly jurisdictions throughout the United States, which is what the Court of Appeals found, was that from a probable cause analysis, the Court of Appeals could find no jurisdictions that didn't allow HGN to be used as a tool. And the courts, both the Court of Appeals and the District Court, used HGN as a tool for determining probable cause.
So you believe that there's some validity to use this test as a tool to detect alcohol impairment?
I believe that certainly law enforcement throughout the community believe that it is a valid tool in their toolbox to assess impaired drivers.
Even in spite of what courts, and at least the courts in this state, have said about its validity?
I believe that is correct.
Okay.
Even if that, I'm sorry.
No, go ahead.
Even if that is true, do we have the foundation in this case to establish that?
I do not think that the foundation in this case would overrule Whitty. by any stretch of the imagination. I don't think that the foundation is there in this case.
But do we even have it enough to get in for reasonable suspicion? I mean, was there enough of a foundation laid for our consideration of whether we would draw Whitty in to the extent of allowing for a reasonable suspicion?
I think that there was a sufficient foundation. Well, I guess there's two issues. One is whether or not that issue is properly before the court. The objection that was made at the trial court level to the admission of the evidence was simply, it's not admissible for any purpose. There was no real cross-examination of the officer. There were no questions regarding foundation, and the Court of Appeals, in my opinion, held or concluded that that issue really wasn't properly before it and wasn't properly raised and preserved at the district court level. The foundation in this case is weak at best. It should have been flushed out a lot more. Do I think that there is enough foundation for the test to be admitted? Yes. And the only reason why I say that is I look at the Shadden opinion and look at what precisely was elicited from the officer. And the officer does not testify that 4 clues means that he's over a .10. The officer doesn't testify to the scientific nature of the test. All the officer testifies is that he passed or failed. Much like the Shadden analysis, that testimony is appropriate. And again, we go back to the weight and...
But what does fail mean?
Fail means that for this particular test, more than 4 clues would indicate a BAC of more than .10.
Well,
So you are correct.
I mean, you're using it for, you're saying the officer didn't testify, didn't quantify what it meant, but he did, because if it doesn't indicate .10 or more, then he didn't fail the test. I mean, that's the whole purpose. You're sort of splitting hairs there. If you fail the test, then that means not just that you've consumed, but you've consumed enough that your blood alcohol content is over the legal limit.
But it appears to me that splitting of hairs was what this court did in Shadden, which was allowed the officers to testify that and I understand that Shadden did not talk about HGN, talked about the other tests.
And wasn't that to the jury?
Yes, that the officer could testify that the test was failed, but could not testify that failing the test meant a BAC of X. So I do think that there is a splitting of hairs in this type of analysis. I have a brief time left. I'd like to move on to the second issue, which is whether or not there was reasonable suspicion based on all of the information.
What of the factors would indicate anything more than Mr. Molitor had consumed alcohol?
He had a traffic infraction. He failed to signal his turn. He admitted 2 to 3 beers. He had bloodshot eyes.
Now, the admission of 2 to 3 beers, the bloodshot eyes, and the watery eyes or whatever, those indicate consumption.
He had some difficulty following the instructions during the other 2.
But he passed those. Now, you're using the clues. That's what I had a problem with the Court of Appeals. They used the fact he had clues on the field sobriety test, but he passed them. The only one he didn't pass is the one we're arguing about today. He failed the HGN, but he passed all the rest of them that are recognized as being legitimate. So if he passed the test, how can you use that as an indicator that he was under the influence?
But I think if you look at Edgar, if you take the analysis that, well, if you pass a field sobriety test, you can never be guilty of a DUI or a drug impaired charge, you're not looking at the totality of the circumstances. There was certainly more in this case than there was in the Pullman case, which was simply an odor of alcohol and refused to comply with the officer's instructions.
But is the test substantially dissipate if the officer observes clues of consumption and perhaps erratic driving, then he has to do so well on the field sobriety that it substantially dissipates the other clues? How is that a totality of the circumstances analysis? Why don't you view them all together? He passed some, there's some indicators of not being DUI and some indicators that he might be. Why isn't that considered all together?
I think that the court and the officer does have to look at all of those together.
So would you say that the Court of Appeals applied the correct analysis to that when they said they required that the passing the field sobrieties substantially dissipate the other clues?
I don't believe that the district court applied the right analysis in this case. And I would have to pull the Court of Appeals opinion to see exactly what they said. The other factor in this case was that he bumps and parks up on a curb. So you do have more erratic driving in this case. And I think that you do have to look at, from start to finish, the entire contact of the officer with this individual. And when you look at all of those, and again, we're not talking about beyond a reasonable doubt, we're not talking about probable cause, we're talking about reasonable suspicion, which is a lower standard.
But we've defined reasonable suspicion as being based on substantial, competent evidence, have we not?
Yes.
And what does competent evidence mean to you? Can you have inadmissible evidence that's competent?
No.
So how do we get around that?
But the only, if I agree with your argument, the only inadmissible evidence that we have in this case is the HGN. So if I look at all of the admissible evidence, I have the officer's testimony that I have a traffic infraction, I have an inappropriate stop when I activate my emergency equipment, that we hit the curb, we go up on the curb. I have good behavior. He's able to get his license out. He responds appropriately. I have questionable behavior in that bloodshot eyes, admits to 2 to 3 beers. I have a strong odor of alcohol. He gets out of the car, does pass, quote unquote, the walk and turn in the one-leg stand, does have some inability to follow directions. And I think all of those together gives the officer reasonable suspicion to request the PBT, which is the next tool in this toolbox that the officer uses. Thank you.
And the strongest case you have to support this constellation of factors would be Pullman, is that what you said?
Pullman, P-O-L-L.
I understand, I just was clarifying it's Pullman
Yes.
you're talking about.
Yes.
All right, thank you.
Thank you.
To answer your question, Justice Rosen, the HDN is still being performed because the National Highway Transportation Safety Association evaluated the standardized field sobriety tests, one-legged stand, walk and turn, and HGN together as a combined unit to basically, they're all to be used at the same time to give a complete picture about whether or not the person is under the influence or not. I've argued previously that if HGN isn't admissible, the other two aren't admissible either, because the standards that were set by for the final finding, if I remember correctly, from the Highway Transportation Safety Association, was based upon the application of all 3 standard field sobriety tests.
Well, by implication then, it seems they validated it if they included in there. I mean, they approve the use of HGN, the National Traffic Highway Safety.
I believe that it was part of the testing originally back, and if I remember, I think this goes back into the 70s or 80s.
Right, I understand originally.
Yes.
I'm perfectly aware. We're talking 2014. Is it still being prescribed as part of the reasonable suspicion or the tools that are in the toolbox, so to speak?
That I honestly don't know. I was trying to explain my belief for why I believe it's still being taught to law enforcement, but not whether or not it's been approved by anybody else. And I think that's beside the point. I agree with the court. It's not admissible. Hasn't been for 30 years.
I have this recollection of a grid in police reports where they had one axis was the walk and turn, the other was the one-leg stand, and you take the number of clues on each and go, and it had to, but it didn't include the HGN on that grid 20 years ago.
At least in Sedgwick County, and actually no other county have I seen, there is a box for the walk and turn, different indicators. There's a box for one-legged stand, and there's a box for HGN. They take off the indicators and give a point total, and that's still in the standardized police reports. So it is still, I mean, it's still being used that way. Nobody's told them not to, I guess. Field sobriety tests are given to somebody in order to confirm that they are under the influence, or to show that they are not under the influence. And in this case, they confirmed that Mr. Molitor was not under the influence because he did not fail them. It is specifically motor control tests to determine whether or not the person is capable of acting in a physical manner, and if that is being impaired by alcohol. So my belief is that they weigh stronger than the officer's observations, in that he was capable of passing these tests, because they're designed to add a cutoff as to whether or not the person is under the influence. And unless the court has other questions, I'll actually sit down early.
Any more questions? Thank you, counsel.
Thank you,
Thank you
Your Honors.
both for your arguments this morning. Court will take this matter under advisement.